Hi, everyone. Welcome to another video with the Financial Advisory Group. Today we have a very special guest. We are joined by Mac Brillhart. He's a trusted partner of the Financial Advisory Group and the head of the estate planning division at Stock and Leader. Mac specializes in estate planning, estate administration, elder law, and fiduciary litigation. He's helped many of our clients with everything from drafting wills and power of attorney to drafting more complex estate planning strategies like Medicaid and guardianship planning. Mac has just been an incredible resource for our team and our clients, and we are excited to have him here to share some of that experience with us.
Welcome, Mac.
Yeah.
Thanks, Damien.
Thank
Thanks,
you
Ben.
again
Well,
for
happy
your
to be
time.
here.
Yeah,
Thank
and
you.
just to add before we jump into the interview, I think I've been here at the firm now for 25 years, and I think ever since I've been here, we've worked with Stock and Leader and Mac, so that our trust as a firm relationship goes a long way, and we're excited to get the chance to get Mac on a call here today.
Yeah.
Appreciate it.
Mac, anything I missed from your bio? It was hard to consolidate everything from your website. You have a lot of accomplishments, so hopefully I covered everything.
All
Uh,
good.
yeah, okay. So we will dive right into it. First, the biggest question is, what is an estate plan? A lot of our clients, this is maybe something that they procrastinate on, something that we put on everyone's checklist. Everyone we think should have an estate plan. So maybe you can give an overview and maybe why some would procrastinate on this.
Yeah, we have a similar experience with folks wanting to avoid the process of talking about death and falling ill, become incapacitated. So I think the term estate is misleading to people. We think of estates when people are deceased, right? Estate planning is certainly planning for when you pass, whether it be through the use of a will or a trust, other instruments. But we also find people neglect planning for while they're alive, right? So whether it's a use of a power of attorney, medical, financial, I would describe it as planning for, the worst is when you pass, when you're ill, when you become incapacitated.
And we found Mac more recently with clients, right? Again, they hear that estate plan. I've been through it went through it with Mac. That once you have kids, it almost freezes you because you feel like I have to appoint a guardian. But I think we find more with our client base, the will's important, but that power of attorney can almost be, in some cases, more important. It doesn't turn more important, but just as important. And that's something, like you said, that could be needed much before the final will at any point in time.
Right. Yeah,
Yeah.
we have clients routinely, come in, I need a will, and just neglect the power of attorney. And I mean, really, if you become incapacitated, you're in a hospital, you're in a nursing home, and your spouse, your kids, your loved ones don't have a document that gives them decision making authority, and the person can't at that point sign a power of attorney, they've lost their capacity, you have to go to court. You have to go in front of a judge, you have to have doctors testify. It's expensive, it is not pleasant. And I guess one takeaway I would mention for estate planning generally is the ability for you to make your wishes known in writing when you can. Those moments can vanish in a heartbeat, not to be dramatic. And then we don't know what you wanted, right? And B, it's too late, and we're having a judge make decisions that you could have.
Yeah. Yeah, good points. And we've kind of touched on a little some mention of will, some of power of attorneys. Can you go over like what are the key documents that everyone should have, and maybe a brief overview of what they are?
Sure. Yep. We refer to them if it's a couple, for instance, we refer to them as the legal six pack. So that's a will for each spouse. We often have people think that married couples share a will. They may be reciprocal and mirror wills, but they each have their own wills. So two documents there, and of course, again, the wills are covering where your assets pass, to whom, and what percentages, who your beneficiaries are at your death. We can structure inside the will ages that minors receive their inheritance through a trust, through built into the will, through a custodial account. Importantly, you can should identify who your children would go to live with, who would become their guardians, sort of a custody type animal in the will, who your executors are. So wills take care of all that. Financial powers of attorney. So I become incapacitated. I nominate my wife to handle my bill paying, my tax returns, anything financial under the sun, I delegate to her if I can't do it. And similarly, we have a medical power of attorney with an advance directive in it that is, again, directing who I want to make very significant, perhaps end of life medical decisions for me if I cannot. So that's sort of the package of documents. Now, obviously, we use the proviso of everybody's situation's different. Some people have some other documents that are not built into that standard 6-pack, but that's the starting point.
And I guess
Gotcha.
on that, there's a lot of terms that get thrown around. And I guess the question we'd have is, you talked about the medical power of attorney, the financial or durable power of attorney, the executor, executrix. You can have different people in each of those roles. And I guess also it's important, at least from our understanding, right? The power of attorney is they have power while you're here on earth. The executor or executrix has power when you're not here anymore. So it's important that, right, some people will have this confusion. If you can go through the difference between that executor role who says, oh, I have an executor, I don't need a power of attorney. Do you mind it? That was a lot to ask you, but just those different roles and how they can be filled.
Yeah, well, first of all, they can obviously you pick, you select, you nominate who you want, right? So when we sit down with clients, we're explaining the function of each role. You're exactly right. That not to be too technical, we try to get away from people saying he's my power of attorney. The document is a power of attorney, but the person in it is an agent. Although I think that's probably not significant.
Sure.
That person that you nominate either medically or financially to handle your affairs under a power of attorney is a lifetime distinction. So you are exactly right. We have people, someone passes away, they're still going to the bank using the power of attorney, signing checks. I don't think the police are going to break their door down and arrest them. But that document, the power of attorney dies when the principal dies.
Mm-hmm.
And although that power of attorney may also be named the executor, that executor has to get appointed, typically through the Register of Wills office, and his power of attorney hat comes off and his executor hat goes on. Still handling financial decisions, liquidating, paying tax, consolidating assets, similar jobs, but very different in time.
Gotcha. And are these, if you name, so let's say myself as a client goes to Mac's office and I draft up my estate plan, and I name XYZ Bob as executor and Sally as my POA. Are these conversations that I should have with them? Should they know about it prior to the documents needing to be used?
Great question. Yeah, I mean, we urge people to do that. I've had some very uncomfortable situations. I had a situation where a person nominated a guardian to take their minor children, also nominated that person to handle the minor's inheritance in a trust, and person died. Lo and behold, the sibling they nominated didn't want to do it. Very awkward, right? So, and in that case, it was more so my plate is full. I have 3 little kids of my own. I don't have the capacity to do this. Going to your loved ones and explaining, hey, these are really significant decisions, and responsibility. Are you up for the task is key, because we do try to build into the documents that if Bob can't do it, Sally can do it. If Sally can't do it, Fred can do it, and have contingencies layered in, for that scenario where somebody doesn't want to do it, or Bob has died, or Bob is sick. So we try to get ahead of that, but I think it's good advice to have our clients talk to the people they want to name in these roles to make sure they're interested and want to do it. It's a good point.
Yeah, and you're kind of alluding at the fact that maybe someone might not want to do it. I personally have not been an executor yet, thankfully, but I've heard from many others that it is a big job, and you kind of alluded to that. Can you describe like why some people may be overwhelmed, why some may not be qualified, or any insight you have on that?
Yeah, I mean, without getting too far down in the weeds, if you think about it from 1,000 feet, someone passes away, their will is probated with the Register of Wills, the executor is appointed. The executor now has effectively a court order called a short certificate to carry around to deal with financial advisors, to deal with banks.
Yep.
What we typically tell them their job is, again, from 1,000 feet, is to first identify assets and debts. So, do they own vehicles? Do they own real estate? We got to get our arms around, and you can imagine that could be a huge job. People have business interests, farms, rental properties, vehicles, bank accounts, life insurance policies, retirement accounts. So the first idea is to get our arms around identifying what are the assets and who are the creditors. Who do we owe money to? So once we've identified that, we start to put a plan in place of what assets the beneficiaries, and the executor is the one leading this march. The executor may be getting advice from me, but he's the client, he or she's in charge. Once we've identified those assets and liabilities, we start to determine what assets want to be retained by beneficiaries. Maybe somebody wants to keep the house, keep the car. So it's not a wholesale liquidation right away. It's talk, and that's a very, it can be an interesting experience to have, different beneficiaries want the same asset. They don't want to pay for it. They don't want it to diminish their share. Probably going down the weeds here. But
Right.
once we've identified what assets are going to be kept and retained in kind versus what assets are not, then we want to liquidate those other assets that we're not retaining, right?
Yep.
And we want to consolidate the sale proceeds into an estate checking account. So now we have sort of a general house account that the executor has a checkbook, and we are having the executor, not mix his or her own money with the estate. It's its own entity, has its own tax ID number typically, and we're paying bills and we're depositing refunds in and out of that account. That account is going to be our mechanism to file ultimately an inheritance tax return, right? For items that we can deduct. So again, identifying what we have, what we owe, consolidating assets. Once we consolidate assets, we determine, is the estate solvent? Do we have more money than debt? And if we have more money than debt, we start paying off the debt. We want to pay Pennsylvania is one, I think, of only 8 states that has an inheritance tax. So we want to keep that on our radar. It's due 9 months from date of death. So we're educating our executor about that looming deadline. If you pay it early within 90 days, you get a 5% discount. So we want to try to, our nice tight-fisted York County folks like those discounts. I know I do.
Yes, we do. Yep.
So after we've paid our debt and we've paid the tax man, we now have net numbers, right? And at that point, we're ready to distribute assets, distribute cash. That executor, we help him or her prepare an accounting that identifies we started with this, we paid this, this is our net number, this is how we're distributing it to the beneficiaries. And then we're going to send that accounting out to everybody and have them fly spec it and sign it.
Yep.
So that's how I would describe from 1,000 feet what an executor does.
And
Yeah, and I have one other quick question on that before Damien jumps in. How would you advise someone to pick that person? Is it like pick the child that's the closest to you? Is it pick your estate planning attorney? Or maybe the person maybe you have a financial advisor kid. Do you just pick the most financially savvy? Anything on that?
Yeah, you're going to get different answers on that. I mean, my 2 cents would be the person's ability to handle. You don't have to be a financial advisor or a lawyer to be an executor. And I would even say, as someone that's a tight-fisted York County person, if you, I mean, we attorneys, advisors are sometimes able to serve in that function as a trustee, as an executor, but we charge for our time. And so I think that if you have a family member that's up to the task, and we have to remember that family member still has a right to charge for their time. It always makes me feel good growing up here how many times I see people waive the fee. And these are my parents and these are my siblings, and I'm not going to take any money for doing that. It sort of makes you have some faith in society yet. But I think to answer your question, we start with, do you have a trusted family member that can handle this, that has integrity, that has some basic financial skills? And I think if they check those boxes, that's more important than where they live. Nowadays we can use Zoom, we can have teleconferences, and you can handle things from afar. Although I have to temper that and say, if there's real estate to sell or real estate to supervise and watch over, you have to put that into the soup too.
Yep.
So I think location's important, not as important as the executor's ability. Trying to think about whether I answered the whole question there or not.
No, I think that's good. And I think, Ben, to start where you started, right? You haven't been an executor yet. I sort of have this joke, I guess it's half a joke, is when you find someone who says they want to be an executor, it's because they've never been one. I think some people have this misconception that the executor, and unfortunately, I have been an executor, and there's this conception that the executor has power, right? And I try to explain, and Matt, correct me if I'm wrong on this, that all the executive's role is to carry out the will, right? I don't get to make decisions, right? When my dad passed, I couldn't say, I like myself more than my brother and sister. He said a third, a third, a third, but I'm going to make it 40, 30. I couldn't. The
Right.
executor's role is to carry out what that will says, point blank. So I think a lot of people have this misconception that this executor is this powerful role where the executor, you just listed it, just has a boatload of work to do. And that's the joke, is if you say you want to be one, it's because you've never been one. So that's just
Yeah, and our job, and part of that is to lay out what they need to do and in what order, and give them instructions. That we don't have to perform all those functions. We're simply giving advice as to what to do and when. I mean, I had someone call in yesterday, again, 3 children, and they don't get along, the siblings, and the executor basically went into the house, removed all the personal property. This is not my executor. Went into the house, removed all the personal property. Get a little sun here. And now the personal property is gone. And the client that wants to hire me lives in California. Never had the chance to go through, and there's sentimental jewelry that's missing. And so Damien's right. The will said my personal property goes to my 3 children in equal shares. That executor should have given his sister the ability to walk through the house with him.
Yep.
And he didn't follow the terms of the will. Now he's subjected himself to me.
Yep. And you don't want Mac coming after you, just a rule of life. And one other thought there, and to sort of pardon or move off to a different topic, but I think one thing, Mac, that I think is important, and Ben, for us to talk to our clients about, is the more organized you can be prior to your passing, the better, right? Because whoever this executor is, whoever, and what we'd say this for, even not just for the kids in general, that if there's 47 accounts floating around out there, that can cause issues, not just for the executor, but it gets more infighting. That the more organized you are, the more consolidated things are. And I'd argue the more the kids know about the situation, the smoother the whole estate process goes. Where when you have the situation where someone passes and there's very little knowledge to that next generation of what was out there, it can be a nightmare. Because like you just said, well, there's 17 accounts. So part of our goal as we talk with clients is, as once you retire, that's a big event, start working on simplification so that when something happens, there's a plan in place and it doesn't take all this legwork behind the scenes. So I think that's important, to sort of try to simplify some of this stuff before you pass.
Yeah, you think about someone dealing with their parent dying, for instance, and that's emotional. And you sprinkle on top of that, I don't know what accounts they have. I don't
Yep.
know what credit cards they have. I don't know. I mean, and I think if someone's private and they don't want to share that financial information, so be it.
Yep.
But creating, a record book, a central guide of what I own, who do I owe, is a good thing for an executor to start with. I always think giving examples is helpful. We
Yep.
had a case where the decedent was super tech savvy, and everything was, on his computer. He didn't get any mail, and his computer was locked down, and his brother couldn't get into his computer. He knew he owned a house and a car, but we had to go through a nightmares process of trying to get the hard drive out of the computer
Wow.
and going to Apple and getting court orders to get into it. And it was, I mean, it was really, it cost so much time and money
Yep.
to unpack what the guy could have written down on a piece of paper.
Yep.
Wow. Yeah, that is a lot. So I know we've touched a lot on like an executor, which they have a lot of the duties once you pass away, but let's focus a little on the powers of attorney that we touched on a little earlier. So first off, there's a lot of terms under the powers of attorney, but let's just start with the financial one. What can the financial power of attorney do?
Well, the principal is the person that grants the power of attorney. So the client that's giving the POA out to the agent, the Pennsylvania statute, it has a very comprehensive list of, I would say, anything that you can do yourself. And if I think about that for a moment, I say, if I'm in a car accident tonight and I go to York Hospital and my wife needs to be me financially, she needs every power that exists because we don't know what's going to come up. It could be
Yep.
sell a car, sell a house, deal with banks, deal with financial institutions, deal with the IRS. I mean, it is a huge, broad array of powers. If you trust the person,
Huh.
and hopefully you're not naming somebody you don't trust, that broad array of powers, I think of as a positive thing.
Yep.
Um, that's sort of I call them everyday mundane powers. Keep getting into the sun here.
Yeah,
Sorry.
you're getting brighter, this is great, Mac.
So we, and then Damien's heard me sort of sound silly. We have these other powers we call superpowers,
Yep.
or people refer to them as hot powers, and they're sort of above and beyond these everyday mundane powers, like making gifts,
Yep.
or retitling assets, or altering beneficiary designations. And you think, wow, if I'm sick, do I want my power of attorney to pay my bills? Sure. Do I want my agent under power of attorney to gift my money away while I'm alive? I come out of the coma and my money's gone. Do I want my agent under power of attorney to retitle my house, to
Yep.
retitle my car? Do I want my agent under power of attorney to change a beneficiary on my life insurance policy that I designated? Those are major powers. That's why they're superpowers.
Yep.
So I like to separate that when I talk to clients into, here are these everyday things you got to give out. And then there's these other things that as estate or elder law attorneys, we like to have them in our toolbox.
Yep.
So because there's reasons that we want those superpowers. It could be that we're protecting money from a nursing home. It could be that we're protecting money from inheritance tax.
Yep.
And those powers can make us nimble and can make us use strategies that we would be telling the client what to do, but the client can't participate, right? Because they're incapacitated. So those are really important discussions on the amount of trust that you give the agent and how much leeway you want to give as to these superpowers. Now, I feel like we do a nice job of handcuffing the superpowers.
Yep.
So I can say that I give my wife the ability to gift my assets away from me, but she can only gift them to her and my children.
Yep.
Right. So if she meets the pool boy, she's not giving them to the pool boy. So I think we do a nice job, and I've worked with Damien on this a lot, of talking through the superpowers, but using the superpowers in ways that were still semi-protected.
Yeah.
And I think
And
that was a good way to put it initially, Mac, is, I think the power of attorney gets this. Some people think, right, it's scary to say, hey, I'm going to let Mac act in my wait. And you think it through. It's like, wait a second, he can do it, right? But if you can't do it, you need someone to operate your everyday life, right? It's a bigger risk to not have that document than to have the document. And I think having that conversation with you is excellent. Of this is, again, having some ability to limit those superpowers, but there are times when those superpowers, they're super, right? To be corny, and you want them to be available. So I think that's interesting.
Yeah, and we have other times, interestingly, where someone doesn't have someone in their life that can do this.
Yep.
And there are agencies out there. There's professionals that can act for a fee,
Yep.
that can help people out. The other thing you made me think of, Ben, was this idea of a springing power of attorney. And I do have people, like Damien said, that wait a second, so Damian Lynch can just get into my bank account and he could sell my house and all these things. And you say, yeah, that's
Yeah.
sort of the purpose of it. You say, well, could he do that when I'm not sick? And that's what Damien used the term durable power of attorney, that the power of attorney is live when you sign it. One of the things we tell clients is, if you're perfectly fine, my parents are 80 years old right now. I'm an agent under the POA financially. It's at their house.
They actually trust you, Mac.
They actually do.
All right.
But so I don't have custody of the document, right? So now I know where the hidden key is at their house and I can go get it. But we tell people, maybe if you're perfectly fine, you tell the children where it's located.
Yep.
Because if they can't find it, what's the purpose of the whole thing? But they don't have access to it, can't use it until you need them to.
Yep.
That's, I think, a good approach. Now, I have some very nervous Nellies that are like terrified, and you wonder why they're naming somebody if they're so terrified. But everybody's different, and they want to use what's called a springing power of attorney. And that springing power of attorney says, these people are not handling my affairs until I become incapacitated. And there's very bold language in the document that the agent has to produce an affidavit from a doctor.
Yep.
That the person's been declared incapacitated. And they got to do it every 6 months. We can even build it that you got to get it from 2 doctors. And so in my experience, having dealt with that, doctors are busy and they don't like signing affidavits, and that could take 4 to 6 weeks.
Yep.
So the risk of having that kind of POA is nobody pays your bills for 6 weeks while we wait for the doctor to sign the affidavit.
Yep.
So you have to weigh those things.
And I think and we'll try to jump off to the next topic then too, but just a note there for, right, when someone has a power of attorney from our side, right? So Mac's drawn the power of attorney up for somebody, and someone just tells us, the son calls in and says, hey, I'm power of attorney. We can't do anything. That telling us that means nothing, right? We need, as our firm, to get that physical document signed by not only the person who granted the power, but then also, and I had a conversation with Mac on this just recently,
right,
that also the person you are granting that power to, the agent, correct me if I'm using the terms right, has to have signed that document as well, accepting that power. So you can tell us on the phone. So it's important, again, for clients listening, that if you want us to have a power of attorney, just telling us you have it doesn't help us. We need the physical document here in order to actually use it. And again, it has to be signed by not only the person granting the power, but the person accepting the power has to acknowledge that as well, or else, again, it's useless.
Yeah, and I know you want to get off this topic, but one last thought on that. That the agent signs an acknowledgement. That's what Damien's referring to, that I often refer to it as I won't lie, cheat, and steal, basically. But that acknowledgement need not be notarized or witnessed. So the individual granting the power, what I call the principal, their signature is witnessed and notarized, right, when we create the POA. And I often tell people, you don't have to give it to your son yet. You're perfectly fine. Keep it at your house. tell him where it is in case something bad happens, and he can sign it in the future.
Yep.
Maybe he never uses it and never signs it. That signature, no notary, no witness, he's off and running.
Great. Thank you.
Gotcha. And getting kind of on the same vein, still power attorney talk, but into the medical side, a lot of people are concerned. Is it a medical power attorney or medical proxy? Is that just someone who can figure out when they want to unplug the machine?
So, yeah, there's two parts to our medical power of attorney. One, I'll sort of call it non-end of life, and the second piece is end of life. So, the medical POA has everything from making, non-end of life medical decisions, consenting to surgery, consenting to the admission into a hospital, the admission into a nursing home. So, prescription drugs. So, you have this sort of I make my own medical decisions. I become incapacitated. My spouse makes them for me. And they, like the financial POA, are sort of everyday medical things.
Yep.
And then towards the latter piece of our medical document has a POA in it with an advance directive. So that you may refer to that as a living will,
Yep.
and which is not a will. People are just, they confuse the two. But the living will is giving instructions, as Ben, politely put it, of pulling the plug. So, now we are in an end of life situation where someone cannot get better. They're permanently unconscious and they do not want to be kept alive artificially. And so that living will is critical in giving, the agent instructions on when I want to be removed from life support, what pain management I want, what organ donation I want. So that is all built into that document, both non-end of life and end of life.
Is this the person that would also put or some people are concerned about their kids putting them in a nursing home. Is that something that would be under the medical power of attorney or financial? Because it seems like it kind of covers both sides.
Yeah, I think it does. I think it does cover both. When you sign someone into a nursing home, for instance, you're using some, financial discretion that you're going to pay the nursing home. So I think you could argue you need both of them for admission financially and medically. And the key to that is, again, much like the financial, the medical power of attorney has a selection in it initially that says these people can act for me only when I'm incapacitated, right? So if I've had clients call me up and say, like, my son's trying to force me out of my house and move me into a nursing home, right? And you say, all right, well, let's talk about this and try to glean whether the older individual still has capacity legally. I'm not a doctor, but I can talk to them and sort of, you remember what your address is, what's your date of birth, things like that. And if they're still have capacity, they can rip up the power of attorney immediately and fire the person. Send them a notice you're fired. And then that son has no ability to do anything. But where it gets tricky is, you sense that maybe the person does need to leave their house.
Yeah.
And maybe they don't have capacity. Well, if they don't have capacity anymore and they rip up the POA, maybe they didn't have the capacity to revoke it.
Yep.
And maybe it's not really revoked now. So that is, I never like those calls, but they keep coming.
Yeah.
Gotcha. I guess we can touch on a little on some special considerations, and this would also kind of go into what we talked about before. You briefly mentioned trusts. I know Damien and I have dealt with some clients that maybe have a trust, they don't even know they have it, and they never retitle assets, or maybe they don't need a trust. So what is a trust? Who's the person that actually needs one?
Yeah, good, very broad question, but good question. So I'm not, and Damien's heard me say this a lot, I'm not a huge proponent of revocable trusts or revocable trusts, however you want to say it, in Pennsylvania. We do use them. I've written them, working on one with Damien right now.
Yep.
But I want to distinguish between a standalone trust and a testamentary trust. So, I have a trust in my will that's a testamentary trust. It's built into my will that directs what ages my kids inherit money. I don't want them to get their money too early. that trust will not come to life until I'm dead because it's in my will. That's the typical type of trust we're using. Although you can create a standalone trust that's basically the substitute of a will. So I create a living revocable trust. It's its own document, and it's very similar to a will. It directs where my assets go when I die, same as a will. And as you said, you have to put the assets in the trust.
Yeah.
And I've seen many a trust peddled by, shiesty lawyers, shiesty financial advisors that come and meet somebody and give them this beautiful leather-bound book, charge them $5,000, and they're on their way and never see them again. They never put anything in the trust. Very frustrating, gives our profession a bad name, frankly. So I think the important discussion is, what is the benefit of that revocable trust? To me, the main, maybe only benefit of it is it bypasses probate. And so probate in Pennsylvania is not crazy expensive. It's $100 per 100,000, right? So if I have $1 million estate, probate's $1,000.
Yep.
Not that bad. There are things that you have to do when you probate that cause other expense, other documents that you have to file. So there can be more expense than that. But you'll find that if you put all your assets in a revocable trust, it is true that when you die, you won't have to probate. So you've saved that cost, and you've saved some of the bureaucracy that comes with probate. But you will still pay inheritance tax on all those assets. You still have to send notices to the beneficiaries. You still typically have to do an accounting when you go to close the trust and give out the money. You still have to have receipts and releases signed by the beneficiaries when they get their money. This whole, it's private. The document's private is not wholly true, because when you file an inheritance tax return, you have to attach the trust. It's pretty hard to go and find inheritance tax returns, but they are public.
Yep.
So it's not true that if you use a trust, it's private. So I don't know that I would say that they do a lot in Pennsylvania. They do not avoid creditor claims because it's revocable. I can put my hand in the trust, take it back, put my hand in the trust, take it back. I haven't given up ownership, really. We don't avoid creditor claims. We don't avoid nursing home claims. We don't avoid inheritance tax. We avoid probate.
And I think without, we could end up on a longer discussion going down this path, because I know, and Mac and I have talked a lot about this for the last 20 years, it feels like. There's other simpler ways, right, to avoid probate at a much lower cost with things like transfer on death designations, beneficiary designations, which don't let me forget to have you sort of how the importance of beneficiary designations on things like IRAs, life insurance, that versus the will, which I think we'll cover, but that's an important topic. And I think we're winding down on time too. But the importance of having coordination between Mac and myself as to sometimes probate's good, right? If I have, for my boys, and I'll use a quick example, right? Same with Mac. The boys, yes, Liam's 19 and Keenan's almost 17. I think they're great kids. Do I want them getting money? Not a chance right now, right? If I use transfer on death designations, it's theirs. Using probate, I have trust that Mac designed for me, testamentary trust, that it would go to them at certain ages. So probate gets this bad rap. Sometimes probate's good. You want to use it, right? That there's a positive part to it. And I think that's the part that, it just somehow probate has this negative connotation, where to us, there are certainly situations where probate's important. So I said a packed lot there, but Mac, if you just sort of the difference between that, I guess to jump to, unless I said something incorrect there, because I'm as not an attorney, but the difference between like beneficiary like in my beneficiaries, I have, Mac as my beneficiary. My will says Liam and Keenan get everything. Who wins?
Right. Well, I wish I was your beneficiary. So yeah, this is huge. Maybe this is what we close with. I don't know, but this concept of everyone thinks that their will controls everything is not correct.
Yep.
We go out of our. I do think one of the things that distinguishes our law firm from other law firms is we, in painful detail, and sometimes in painful detail that we are not paid for, we walk through the client of saying, your life insurance is not covered by your will. I usually use the 3 bucket example. The 3 buckets are typically life insurance, retirement accounts, and investment brokerage accounts. So, excuse me, those buckets of money have beneficiary forms, either through LPL, right, your financial advisor, or your employer. At my law firm, I have a 401k. I go to our HR person. I have a form. I write on there when I die. I give it to my wife.
And I
If
hope
my
you're
wife,
matching those contributions, Mr. Brillhart.
I'm doing my best. So I am, naming on that form who my beneficiaries are. And as Damien said, I name my wife, and then on my secondary, if my wife dies before me, I have a trust and I can nominate the trust instead of my kids getting it at 18. But I go through that process with the client and say, you must call your financial advisor.
Yep.
You must go to your employer, and they do not have to match, right? Oftentimes they do. In my scenario, I want everything to go to my spouse, then my kids, and that's everything I own.
Yep.
But that you can slice and dice this however you want. One of the things we do a lot is if there's charitable inclination,
Yep.
we want to use retirement accounts, which are taxable, income tax qualified accounts that we want charities to get them, right? That's a good place to give charities money. But we really want clients to understand. I've gotten to the point where I write them a letter, I send them an email, because we have had times where the client doesn't finish that last process. And when they die, there are adverse tax consequences by not naming beneficiaries.
Yeah.
And I want to be covered that when that happens and the beneficiaries are upset, that I can say, look, I'm sorry, I told your mother and father to do this.
Yeah.
Gotcha. And let's wrap up. I know we're getting long here. You could ask a million questions. Let's wrap up with 2 softballs, kind of 1 to 2. Once a client meets with you, once they have their estate plan, where do they keep it? Where should they store it? And then how often should they update that?
Yeah. So totally the client's call, right? Like they've paid for the documents, they're their documents. We have clients that want us to retain them sometimes, and you'll get different answers from lawyers. Some lawyers are adverse to keeping wills because they're afraid, that maybe the office will burn down, or they'll lose them, or they'll go out of business. So we have a fireproof safe where I retain some original client documents. There's no cost for that. And, we do find sometimes as clients get older, they start to write on the documents in the margins and add things to it. And that can really, it technically can invalidate the whole document.
Right.
So we really don't want people writing on documents, but originals can be retained up to the client at their, where they choose with themselves. They can be retained by the attorney if the attorney has that policy. But we want them to keep them somewhere safe ultimately. A lot of clients, a little advice here, they keep them at safe deposit boxes.
Yeah.
And I think our generation, we don't use safe deposit boxes much, but my parents' generation does.
Yep.
And when you die, if you have a safe deposit box, it has to be inventoried by the Department of Revenue, and you're going to pay money for all that. So I understand that's a safe place, but it creates more work, in my opinion.
Yep, agreed.
So I let it up to the client, but I think those are generally the choices.
And then
And then
how
as far as,
often,
go ahead,
yeah,
Ben.
how often do you want clients to update it? Is it life events? Is it every like a calendar year based thing? What's your advice on that?
Yeah, I think it's more of a life event thing personally. What is a life event? A birth of a loved one, a death of a loved one, a marriage, a divorce, a major change in your financial status, hopefully for the better, the creation or closure of a business interest. Those are things that we want people to be aware that they should dust it off and read it. I don't think there's a bright line rule on this. I have some clients that put ticklers every 2 years on their calendar and they get it out and read it, that's probably not a bad idea. I should probably read mine. But I think, the idea is something significant happens in your life, dust off your documents and read them.
Gotcha. All helpful. Damien, do you want to close us out?
Sure. I mean, first, thanks to Mac, right, to taking this time for us to sort of bug you for, I think we thought it might be a half hour, turned into a little bit more than that, but appreciate the time, Mac. And I would just reiterate a couple things. One, having trust in a firm like Stock and Leader is massive for us. And I think I was telling Ben earlier as we were sort of prepping for this that this goes back to Bruce Wallace 20 some years ago, 30 years ago, who Mac, I guess you can call him a mentor for you, Mac, I would think, who was
For
at Stock
sure.
and Leader ages ago, that our trust between the firms has meant the world to us. As to the firm, it means the world to have someone we can just refer clients to and know they're taken care of. So thank you to Stock and Leader and Mac for that. And I'll end with, it's in our planning discussions, right? Our goal, one of the corny things we say is our goal is to try to fill potholes, right? Avoid things that can happen that could put you down the wrong road. The estate plan portion is a pothole, right? There's a bigger risk to not doing it than there is to doing it. And I think, yes, it's scary. You have to think of who the different designations. But I think it's important to know that there's that power of attorney discussion we had, it's a bigger risk to not have that document. Yes, there's risk to having it, but I think there's a bigger risk to not having it. So we'll end on that note that this is, again, thank you to Mac. And if you're listening to this and don't have the will estate plan done, it's easy to find and get a hold of Mac. He doesn't hide too much. But that's it, Mac. Anything you want to say, or Ben?
No, but I appreciate you and Ben inviting me and really value our friendship and our business relationship. It's been great.
Awesome. Thank you, Mac. Appreciate it.
Thank you, everybody, and thanks, Mac, for your time.